probably communicate later, is to have interim mobile courts in these areas. This mainly because of the remote nature and the long distance the residents have to travel to access courts. As a county, we are willing to discuss and consider the establishment of alternative dispute resolution centers to further enhance access to justice. And this has worked very well, Honorable Prime Cabinet Secretary. The last week, the Land and Environment Court held 3 sessions with the public in Kaloleni, Kilifi, and Malindi. And Lady Chief Justice, this shows that we can solve many land issues if we have alternative ways of engaging. I gave an example, the Lady Chief Justice today, that we have been as a county negotiating with the SCK Church of a land in Kaloleni, which the St. Luke's Hospital stands. This one public participation meeting led by the Lady Justice Odeni last week came clearly that the land on St. Luke's land hospital actually belongs to the county government. And we were busy negotiating with SCK Church to get space while we in really saying the land, the lease expired and the land reverted back to the county. This shows that if we engage and have many land clinics within the county and many other areas of this region where land is a big problem. And you could not have chosen a better place to have this conference than Kilifi, where I think 60-70% of people living in this county are either squatters, but they don't have a security of land tenure in their hand because they have no titles. So I want to thank you very much, Lady Chief Justice, for coming, and also the Prime Cabinet Minister. We will endeavor to work with the judiciary and the national government to see how much we can improve the security of land within the county and in coast at large. In conclusion, the county government of Kilifi is committed to ensure that the principles of environment and land rights of all citizens, as provided for in the Constitution of Kenya, are protected. This view is echoed by my fellow governors from the Jumuiya counties of Pwani, which I chair, and by extension all governors in the country. I will thank you very much. May God bless you, and I want to really ask you all, after the busy schedule in 3 days, I want to tell you, Lady Chief Justice, that this conference have really boosted our tourism. About 2,000 delegates who are attending this conference. If you call the hotels now in Kilifi, you are told every hotel is full. So I want you to extend, after the official participation in this conference, a few more days in Kilifi County. Mujienjoy, asanteni sana and karibuni.
Thank you very much, Your Excellency, Governor. I'm sure we will all heed the call of His Excellency the Governor to extend and to enjoy the hospitality of the people of Kilifi. Thank you very much, Your Excellency, for your remarks. Indeed, the vision of the Chief Justice about social access to justice stands very strong in terms of ensuring that we have justice and courts across the country. Our vision is to have a court in every sub-county of this country. So we are very much in line with that particular desire that you express. It is now my pleasure to welcome the Director of the Kenya Judiciary Academy, the Honorable Justice Smokin Wanjala, to make his remarks. Honorable Judge.
The Honorable Prime Cabinet Secretary, Honorable Musalia Mudavadi, the Honorable the Chief Justice and of the Republic of Kenya and the President of the Supreme Court of Kenya, the Honorable Gideon Mungaro, Governor of Kilifi County, the Honorable the Chief Justice, I would like to request that I adopt the protocol, the detailed protocol that has been called out by our Deputy Chief Registrar, so that I can just make my brief remarks because of the strictures of time. It is my great pleasure in my capacity as the Director of the Kenya Judiciary Academy to welcome you to this conference, which marks the establishment 10 years after the establishment of a critical court in our judicial system, and that is the Environment and Land Court, which was established by the Constitution of 2010. Already a lot has been said about the court. This is an occasion for the court itself to share its challenges, its achievements with the participants in particular and the Kenyan people in general. So I don't want to preempt this momentous occasion. This is the court's occasion. It's the occasion for the Kenyan people, for the people of Kilifi, as the governor has quite eloquently set out. But it would be remiss of me, Honorable Chief Justice, if I just stop there without making just a few remarks to set the ball going. This court, in my view, is an embodiment of the struggle for independence of this country. Because you will recall that with the advent, the conquest of colonialism led to a massive disruption of our orderly tenorial arrangements. It led to massive displacement of whole communities from their land. It led to the introduction and institutionalization of land injustice. So much so that at the time of independence, what we were left with was confusion in tenure and tension between rights, land rights, and almost unstoppable environmental degradation. What this has meant is that the Kenyan people have been left in a permanent state of conflict resulting from the disruption of their tenure. Hence, the need to establish a specialized court to deal with the resultant disputes, the graphic details of which have been laid out by the governor. And therefore, for us, this court represents the continuous struggle for justice, the continuous struggle for land rights, for the poor, for the marginalized, for the vulnerable, for the majority in our country. And so it is the heart and soul of a conversation that must continue taking place on a daily basis, so that ultimately we can anchor our democracy on rights, on protection of the environment, on protection of the vulnerable. And so for me, it gives me pleasure that we have had occasion at the Kenya Judiciary Academy to facilitate the organization of this conference. We at the Academy continue to share in your achievements as a specialized court. We shall also continue to facilitate conversations that are aimed to address the challenges that you face as a specialized court. And therefore, with those few remarks, let me take this opportunity to welcome the Honorable, the Chief Justice of the Republic of Kenya and the President of the Supreme Court of Kenya to make her remarks, and thereafter invite our chief guest. Thank you very much.
Thank you very much, Dr. Justice Wanjara, our Director of the Kenya Judiciary Academy. Honorable Musalia Mudavadi, EGH, Chief Cabinet Secretary, representing His Excellency Honorable Dr. William Ruto, the President and Commander-in-Chief of the Kenya Defense Forces, Your Excellency Gideon Mungaro, the Governor of Kilifi County. I recognize and acknowledge all the judges here, led of course by Justice Oscar Angote, the presiding judge of the Environment and Land Court, the Court of Appeal President, all the judges present, and allow me also to adopt with humility the protocols that have been established before so that I save on time, but say that in a very, very special way, I recognize all of us present in this conference and thank you so much for the support you have given to the ELC and to all the organizing committees that have put together this wonderful conference. Distinguished guests, ladies and gentlemen, I am happy to be in Kilifi today and to be at the Pwani University. I associate myself very, very closely with the Pwani University. I remember when it just started, I came here to give a lecture to the students because I admire the tenets under which this university is founded to serve a wonderful, wonderful community of this part of Kenya. I was also privileged this morning to listen to the keynote address by our visiting judge from Brazil. Thank you very much, Judge, for the very profound presentation that challenged us to think on how we deliver justice, especially because we have a very progressive constitution. We should nurture our own indigenous jurisprudence taken from our own values. That was very good, and thank you very much. Your Excellency the Governor, I confirm that we will work together to ensure the people of Kilifi can access justice, that we will establish the courts in the sub-counties you have mentioned. We are ready, even tomorrow, to start a court in Tuapa. As you all know, we are overflowing from Chanzu, where we house so many courts, and you kindly gave us land last year to establish a court in Tuapa. And indeed, if you are able to set it up tomorrow, I will send you magistrates there. This was not a road-signed declaration that I made when we met with His Excellency the Governor. This is indeed founded in our vision, the social transformation through access to justice, that we will ensure that every sub-county has a court, because there are Kenyans there who deserve judicial services, and we have a duty to ensure that justice is taken there. So thank you very much for agreeing to partner with the judiciary so that we can serve the people of Kilifi efficiently. I start by applauding the presiding judge and all the judges of the Environment and Land Court and the entire organizing committee of the ELC at 10 conference for coming up with an excellent program marked by very innovative ways of public outreach to sensitize the public about the role of ELC and the way we provide environmental and land justice to our people. We keep saying we serve our people, and therefore the people must be at the center of our service delivery. They must understand how we operate and we must get feedback from them the way they want us to serve them. I have followed keenly your tree planting drive around the country, and I applaud you for this practical way of showing the public the need for all of us to join hands to conserve our environment and to protect it. I received a very warm, encouraging message from an elderly man who is a member of my clan, but he doesn't live in Meru. He lives somewhere where you went to plant trees. I think it is Gong, where the judges went to plant trees. And he asked me, how has the judiciary transformed such that the judges can leave their robes and go to plant trees for them in Gong? He was completely mesmerized that judges can go and plant trees. And I said, I will tell them that they have really been admired for stepping and reaching out to the people that we serve. And this is what I would call my self-active justice, which is embodied in the Constitution and reinforced by our commitment to social transformation through access to justice. As Judge Wanjara has said, it is now a decade since our court was established. Much has changed within, and much has transpired in between. And what happened in the environment and land justice space over the time, where we started with 15 judges serving the entire country. Today, we celebrate that we have 53 judges serving in different court stations throughout the country. Moreover, within that period, there has been significant jurisprudential developments that have gone a long way to align our laws, to align the way we do things with the transformational aspirations that are provided for in our Constitution. Therefore, as aptly captured by the theme of this conference, it is time to reflect on the journey the court has traveled over the last 10 years. We must ask ourselves whether ELC has lived to the expectations of Kenyans in creating a specialized court focused on redressing environment and land conflicts. Also, knowing the centrality of land and environment, the question we should be asking ourselves every day is, how is our land and how is our environment? Yesterday, I attended another equally powerful symposium to celebrate children, because this month in the judiciary, we focus on justice for children. And therefore, at that conference, we resolved to be asking ourselves every day, how are our children doing? So in the same vein, from this conference, we should always be asking ourselves how our land and how our environment is doing. Because I think both the three are very, very critical to us. Our children, our land, and our environment. Am I correct? We must also ask ourselves whether ELC has deepened access to justice. But that is not all. In addition, the 10-year anniversary celebration is also an opportunity to look into the future and think of the challenges that remain and those that are likely to emerge as the court begins its second decade and how to tackle the challenges. Moreover, we must also look at the opportunities that will come with this second decade and see how we can exploit these opportunities to have a transformative impact in the Kenyan society. our chief guests, distinguished ladies and gentlemen, one of the unique features of our Constitution is the level of attention that it gives around the conservation and management and sustainable exploitation of the environment and what has been called RAD question locally and the survival issue internationally. Coming just after the Bill of Rights, our Chapter 5 of the Constitution on land and environment raise our transformative normative standards and the rules intended to enable the realization of the well-being of Kenyans through not only the protection and conservation of the environment, but also by ensuring ecologically we sustain the development and the use of our natural resources. We also have to address the issue of the equitable efficiency and productivity, as well as the sustainability of the land ownership, the land holdings, the subdivision, the multiplicity of subdivision of our land. When I was a trial judge in the High Court, in probate and administration courts, I always wondered, why are people subdividing the land to such an economical units? And I always wondered, why wouldn't we think of changing our attitude to land ownership, and so that if a father or whoever is the one who has left the land for the family, they can own it in trusts for them to use it without having to subdivide it to those small portions. But they kept on telling me, in Kenya, everybody wants to feel and to touch that they owned an inch of land. So this is something going into the future we are going to look into and engage Kenyans in that conversation. The ELC is anchored in the Constitution under Article 162, 2 and 3, where it is envisaged that the ELC will be amongst the institutional drivers of the realization of the dream of how we can transform our land tenure, transform our environment and land governance through adjudicatory mandates over the questions concerning our environment and land. We must address how ELC will perform in the future given the lofty aspirations that are articulated in the Constitution. I have read through the ELC casebook titled 10 Years of Dispensing Environment and Land Justice in Kenya, and I have noted some very notable outputs, and based on my own assessment of the case law generated by this court over the last 10 years, I can confidently say that the ELC has lived up to the expectations of Kenyans in creating a specialized court that is focused on access, that has pronounced the rights and duties respecting the environment and land. For that, we need to appreciate the ELC court. The case law from this court shows the emergence in our country of what I call transformative environmental constitutionalism. This is a jurisprudence that marries environment considerations on the one hand and social justice considerations on the other. The court is leading the way in forging a jurisprudence that embraces the integration and balancing of the environment, social and economic considerations in environmental decision-making. This emerging jurisprudence from this court shows that environmental law can contribute towards radical social change and the attainment of socio-economic equality and justice. It tells us that environmental considerations are not only important for sustainable development, but are also necessary for us to holistically address the plight of the vulnerable in our society. This is so because evidently, those who lack access to food, water, sanitation, housing, and health care also often live in environments that are harmful to their health and well-being. The lesson that we must carry forward into the next decade as we celebrate these 10 years is that ELC must be at the forefront in championing a very progressive, social justice-oriented jurisprudence that ensures that we have a clean and healthy environment, an environment that protects the dignity of the people existing within it and enabling their well-being and enabling our communities to flourish. In addition, as we investigate our future and see how best we can navigate and make life better, we must appreciate that the new frontier in environmental governance is climate change. This is so as climate change is problematic. It has affected our environment and given us so many challenges. I can therefore speak like a prophet and say that the most complex and challenging disputes that will come to our courts in the next decade will not be those relating to presidential election disputes, as difficult as it was, or those regarding the constitutionality of the constitutional amendments, otherwise called BBI, as difficult as it is. What will play in our courts are the disputes which will deal with the adaptation and mitigation measures relating to climate change. And I hope, judges, you are hearing this so that you can gear yourself for very, very challenging times as you navigate this to protect our environment, as you navigate this to protect humanity for our own survival. Given that our commitment is to stay ahead of the times and to anticipate any complex issues that we are likely to encounter, I will be working closely with the Director, Kenya Judiciary Academy, and the entire Academy, and also the Principal Judge of the ELC to work towards enhancing training programs for the ELC judges in matters relating to climate justice as a matter of extreme urgency. I've already started a conversation with Justice Benjamin to see how many of you can go to Brazil to go and see what they are doing there, nurturing their own indigenous jurisprudence and systems. The land dimension of the ELC jurisdiction concerns a question that goes to the root of state stability, social harmony, and peaceful coexistence of our nation. And this is why our Prime Cabinet Secretary, we have embraced court annexed mediation. We have annexed these open days activities to have discussions with the people on how we can solve our own problems, how we can empower our own people to solve and find solutions for the problems of land that they are dealing with. The so-called land question has been one of the vexing concerns that is always blamed as the root cause of the numerous conflicts that we experience in our communities. If we can remove the land conflicts in our society, I think we can just talk of very peaceful and harmonious coexistence. Therefore, the Constitution vested the Environment and Land Court with a huge and demanding mandate, and you have been equal to the task. In collaboration with other institutions and actors in the land sector, like the Land Commission, we must all work together to ensure that we play our role in mitigating and resolving these complex land problems. We must appreciate that the constitutional promise of equitable, efficient, productive, and sustainable holding, use, and management of land is transformative, and it is one that promises to ensure that we maintain our environment and also our land governance system that is characterized by fairness, not dispossession, by protecting our public land from land grabbing and other injustices that have contributed to inequality and poverty in our nation. The land question continues to occupy a central place within the transformative imperative signaled in the Constitution. Transformation requires change both in the distribution pattern of property holdings and in how we approach the acquisition, use, transfer, and protection of the land rights. The court must therefore balance several demands. Justice Wanjara just alluded to our colonial period where we were dispossessed of our land, and from there we have never seen land justice. Therefore, the demands of collective justice and the requirements of economic growth and development in a country where land is a key factor of production and a means for the alleviation and the reduction of poverty are equally central. This court is expected to develop the jurisprudence that advances the goal of reversing the effects and legacy of injustices in the land sector, and also so that our social and economic development can progressively bring the changes and the prosperity that is expected. The court's impact on our society is to be assessed on how transformative and friendly the court's jurisprudence and access is and has been in the last 10 years. Going once more to mention what has been documented in the casebook, it highlights some of the landmark decisions the court has rendered in this decade. And I see an emergence of a jurisprudence that promotes constitutional goal of a land system characterized by improved security of tenure, equitable access to land, access to housing, protection from arbitrary evictions, protection of public land from grabbers, and arbitrary deprivation of property. All these cases are documented in your casebook, and they form a wonderful resource, especially for the lower courts and also for the higher courts. When we are determining issues of land, we look into it for guidance. I can say with confidence that there is already emerging from this court a line of thinking and an angle of approach to land jurisprudence that embraces and promotes social justice vision. This is the vision that we are implementing in the judiciary, which is drawn from the Constitution. 10 years of this court has therefore seen impressive progress in our land law jurisprudence, which is a steady foundation, and I encourage the court as we move to the second decade to build on that. One of the drivers of the court to create a specialized court for ELC matters was the perception that these disputes ought to be dealt with expeditiously. Kenyans felt and expressed themselves that the generous constitutional jurisdiction of the High Court was not amenable to the efficiency and focus that needed to be given to resolve the land disputes and conflicts satisfactorily. This means that re-engineering service delivery at the ELC for efficiency is a topic that must concern all of us as we debate and reflect on the past and the future. As we champion the vision, which aims at improved institutional performance and includes the interventions and innovations that we must employ under our vision, I encourage this conference to debate and come up with game-changing innovations and proposals that the court can adopt to ensure that it attains the vision of being a center of excellence in the delivery of environmental and land justice. I encourage the court to continuously work in pursuit of the target of ensuring that its operations provide an enabling environment that ensures our Kenyans get access to justice and also reinforces the integrity of court proceedings while enhancing the public trust in the judiciary. The court should continue in the path of optimizing its operations, the generation and use of high quality and reliable data to enable evidence-based decision-making, and leveraging on automation and digitization of its systems and processes to enhance our service delivery. As I conclude, I encourage the court to continue strengthening its ties with other avenues for dispute resolution in line with the statutory edicts that is provided under Section 20 of the Act that directs the court to use conciliation, mediation, and alternative traditional justice system in the resolution of disputes. Your Excellency the Governor, we have also agreed that we are going to start the alternative justice mediation suite here in Kilifi so that we can promote the mediation and the conversation with the people of Kilifi on how to resolve the land conflict here. Each one of us seated here this afternoon plays the role of one role or another in protecting the environment. That's why we are here, because we associate ourselves with what this court does, either for the land or for the environment. This is either through empowering wananchi, those who work in the civil society. We appreciate what you do by sensitizing them on the importance of protecting the environment. We also recognize the other government agencies, the constitutional commissions, who have put a lot of hours, time, and money fighting and protecting the human rights that are associated with the environment and land issues. The core mandate of this court, which is to administer justice by upholding the environmental rule of law, access to justice, and land dispute resolution, cannot be fully realized without the input and support of the various stakeholders in the environment and land sector, most of whom I see are here today and will be participating in this conference. So in line with our vision for the judiciary, we work towards deepening the partnership that we have already enjoyed and we continue to enjoy with the county government, civil society, our development partners, so that we can enhance coordination in the administration of justice. I encourage all the actors in the environmental and land governance sector to join hands with the ELC to work towards the realization of the constitutional vision of a socially just environment and land regime. I wish all the participants at this conference very, very fruitful, rewarding, mutual exchange of ideas and learning during the conference. And with these remarks, it is now my singular honor and privilege to invite the Chief Cabinet Secretary to present the message of His Excellency the President and for him to declare this conference officially open. Welcome, Honorable Chief Cabinet Secretary, to talk to us.
Please be seated. The Chief Justice and President of the Supreme Court, judges, judicial officers, the Chief Registrar of the Judiciary, distinguished guests, and my good friend, the Governor of Kilifi, Honorable Mungaro. Let me also say that I shall follow the President and adopt the very elaborate protocol schedule that was read out here. So, distinguished guests, ladies and gentlemen, good afternoon. I am here to represent His Excellency the President, Dr. William Ruto. There's been a bit of change in certain things. The tradition has been that cabinet sessions are held on Thursday, but since he came in, it's been moved from Thursday to every Tuesday, every fortnight. So today coincides with a cabinet session, and because of the importance he attached to this day, because I was present when he made his commitment that he would come in the Chief Justice chambers, he said that he shall excuse me from cabinet so that I can come here and represent him today. So let me proceed. I am privileged to join you today as we mark this important milestone in our institutional journey in commemorating the establishment of the Environment and Land Courts. The people of Kenya concretized their family-held conviction that the historical context with colonial claimants must be resolved in favor of Kenyans. The Constitution therefore determined for all time that Kenya is our home and that this land is our land. The establishment of the dedicated institutions for the governance of land and environment is an extension of this aspiration and affirms our commitment as a people to steward our resources as faithful trustees of present and future generations. The land and environmental governance is a domain characterized by interesting tensions that must be resolved to accommodate our aspirations for development and concern for ecological integrity, intergenerational equity, land and environmental practices that are also expressions of communal and cultural identity, and the relationship between modern science and indigenous knowledge systems in conserving biodiversity whilst actualizing economic growth. As a charter to inspire Kenyans in their quest for sovereignty, equality, sustainable development, equity, and sharing of resources, and other national values and principles of governance, our Constitution calibrated a sustainable balance to arbitrate inevitable tensions while firmly steering the nation along a progressive and radically transformative trajectory. Natural resources are vital for human well-being and national development and economic growth. In Africa, the legal system pertaining to land and natural resources has overwhelmingly tended to reflect exclusive and unlimited access by powerful groups, accompanied by their exclusion and marginalization of a subordinated majority. In other words, the institutional framework around land and environmental resources has traditionally been characterized by severe coloniality even after the achievement of independence. This institutional characteristic is a key driver of poverty and inequality and an insurmountable barrier to the attainment of sustainable development. The promulgation of our Constitution as an intentional instrument of decolonization in 2010 therefore represented the realization of the fundamental aspiration driving the bitter resistance to colonialism and brave struggle for independence. This driving force was the quest to regain control over land. Similarly, Kenya's history with regard to natural resources is firmly united with our people's struggle for environmental justice. Once upon a time, state power, government institution, the legal framework, and judicial decisions were organized to achieve and maintain the effective expropriation of Kenyans for the benefit of a colonial minority. Today, they are strategically coordinated to align land, natural resources, and environmental governance with a broader intention to achieve sustainable development. This transformation in the nature, content, and direction of our constitutional, statutory, and judicial system was realized when the objectives which inspired the freedom struggle were finally articulated in our Constitution. It is important to underscore the history, institutional implications, and transformative significance of the Land and Environment Court system in order to establish a sound analytical backdrop against which we can properly appreciate our progress since August 2010. The Constitution mandated a robust Bill of Rights with clear social and economic rights, including the recognition both strong rights and equally effective obligations with regards to the principally land-based phenomena of the environment and natural resources. It also expanded access to justice, mainly by relaxing the rule on standing and the requirement that substantive justice shall prevail over preoccupations with form and technicality. This pioneering approach to land, natural resources, and environmental justice hardly had precedent in our continent and set the stage for the actualization of Kenya's potential to unlock the plenty that lies within its borders. An evaluation of the jurisprudence that has emerged and steadily evolved establishes land natural resources and environmental justice as a foundational elements of radical socio-economic transformation and guarantors of sustainable development. In its capacity as an environmental court, our Environmental and Land Court has also emerged as a salient proponent of climate justice, establishing the constitutional principle of equitable distribution of the benefits as well as burdens of climate change. The ELC has also emerged as a powerful champion of the Sustainable Development Goal adopted by the United Nations General Assembly in 2015. This caliber of emerging judicial leadership has enabled Kenya make progress in fighting poverty while protecting the planet by focusing policy formulation and implementation frameworks on the beacons of people, planet, prosperity, peace, and partnership. Kenya is firmly committed to the achievement of the Sustainable Development by 2030 through the Development Blueprint in Vision 2030, as well as our plan to drive rapid socio-economic transformation in order to attain shared prosperity. For this reason, we have invested effort and resources in various frameworks, including the National Climate Change Response Strategy and the National Climate Change Action Plan, out of realization to enhance resilience and adaptability to shocks exerted by adverse impacts of climate change. These imperatives make it a critical priority to tap into all available potential, including domestic and international, as well as public and private resources, through effective articulation of climate justice. The ELC holds potential to render tremendous contribution in this regard. The ELC, therefore, has a clear and direct judicial mandate that it must continue to discharge with utmost fidelity to the law and the public interest. It also has a cardinal responsibility to anchor discourse on justice and sustainable development. We look to this conference with great confidence because we expect the court, in conjunction with its partners and other stakeholders, to tackle critical issues connected with enhancing the greening of justice, governance, and the law for effective land and environmental management. The role of technology in advancing this agenda must also have a share of your attention. In particular, digitization of land records will present fresh opportunities to accelerate the realization of land justice, creating advantageous conditions for rapid economic growth. Furthermore, this conference will find ample opportunity to exhaustively consider the adequacy of public participation and access to justice in land and environmental matters, climate financing, women and land rights, climate change, urbanization, and disaster risk management. I also note that the court will also launch its strategic plan for 2023 to 2027, which will provide an opportunity for it to build on successes so far, as well as lessons and remedial actions arising from the implementation of the previous plan. The court will also launch 2 other publications: the casebook and the information end-to-end booklet. These publications go a long way in enhancing public knowledge of the court and its processes. I commend the judges for their tremendous contribution to national tree planting. The planting of 100,000 trees in 36 court stations between July and November this year is a highly appropriate gesture that is fully aligned with the court's mandate. It also demonstrates a commitment by judges to provide leadership in efforts to combat desertification and mitigate the effects of climate change. Finally, the judiciary has provided an effective model of how responsible citizens contribute to the greater good. Congratulations. I reiterate the government's commitment to fulfilling its portion of responsibilities to facilitate the court in order to support sustainable access to land and environmental justice. The government pledges to enhance financial support aimed at establishing more ELCs with the objective of eventually having them in every county. On this note, I take this opportunity to wish you fruitful deliberations and look forward to considering their outcomes in due course. Thank you, and God bless you. Now, anything else I say is not the President's remarks. At a personal level, let me just say that indeed I enjoin the previous speakers in underscoring the significance of what has been achieved so far and what we look forward to as we go forward. I'll go straight to the point. I think somewhere the Ministry of Lands is lined up to be here, and other key players. I've seen the chairman of the Law Society or president of the Law Society and other people who are here who are movers and shakers in their own right. I want to state that indeed we have received some genuine representation that the processes at the Lands Office have become inimical to the growth of business. There are inordinate delays in the processing of instruments that are required either to unlock financial resources or to propel certain transactions. As you deliberate here, I would strongly appeal to you, kindly look at that area critically, dialogue with us so that we can partner in making sure that we can unlock what is estimated to be close to 100 billion shillings of resources that are not being released into the economy because there is some inordinate delay at the lands registry on matters that are very critical. If you want to spur the economy, generate jobs, boost our earnings as a nation, we must unlock these resources. So as patriotic Kenyans, let's reflect on it and let's ask ourselves, individually and collectively, is it my act of omission or my act of commission that is deliberately
delaying and slowing down the economy of this country. If you can internalize that, and if you feel that you have been partly responsible for it, kindly change your ways. And if you change your ways, then collectively we shall have changed our ways, and we shall be able to unlock the potential that we also desire to get our economy growing, rather than continuing to see poverty strangling us. So, ladies and gentlemen, have a fruitful deliberation and help us to unlock some of these challenges. God bless you all.
Thank you very much, the Honorable Prime Cabinet Secretary, for those very provoking remarks on behalf of His Excellency, the President. Now, the Honorable Chief Justice, with your very kind permission, we'd like to proceed with the launch, a very brief ceremony on your left-hand side, and I would very kindly request that the Honorable the Chief Justice, together with our Chief Guest, the Prime Cabinet Secretary, kindly to proceed to the launch platform. His Excellency the Governor, the Director, Kenya Judiciary Academy, and the presiding judge. Thank you very much. So we are launching the strategic plan of the Environment and Land Courts. (2023-2027). Thank you very much. Thank you very much. The copies may now be handed over. Thank you very much. That is the strategic plan 2023-2027. It presents the key activities to be undertaken by the court. Together with that, we have the launch also of the casebook that gives the highlights of the key cases that have been handled by that court. May we kindly have copies of the casebook together with the information booklet. We'll hand that over to the presiding judge. You'll then hand them over to the Honorable the Chief Justice, and copies may then be given to the Honorable the Prime Cabinet Secretary. Thank you. Thank you very much. Thank you very much. We may have our seats. Thank you very much. We have come to the end of our official opening, and we are going to have some photographs on the left-hand side, and this will be the order of the photographs. We'll have the Honorable the Chief Justice. the Honorable the Chief Justice, together with the Chief Guest, the Governor, the Director of the Judiciary Academy, the President of the Court of Appeal, and the Presiding Judge of the ELC. We will have the second photo together with the judges of the ELC. After that, we'll have on the left-hand side, this side. Yes, outside there. I'm sorry, on my left.